afternoon. Well done. So it is one of the great privileges of my life as a dean to be able to welcome back a former dean. And that's why she's here. No. Elena Kagan is Associate Justice of the Supreme Court of the United States. She is the 112th Justice. She is the 4th woman to serve on this court. She was born and raised in New York City. She attended Princeton, where she majored in history. She attended Oxford. She attended Harvard Law School. She completed clerkships at the Court of Appeals in Washington and at the Supreme Court. She was a law professor, first at the University of Chicago and then here at Harvard. In between, she left to serve as Associate White House Counsel and later as a policy advisor to President Bill Clinton. She was nominated to the United States Court of Appeals for the District of Columbia Circuit. She did not get that job. She got a better job. She became a professor here and then a dean at the Harvard Law School. She designed this building. Thank you. She led...
The architect helped.
Well, he had a role, but it is what it is because of you. She led curricular change. She brought free coffee. She...
Still what I'm known for.
She made students the center of the law school experience. Hot chocolate also, I should note. And there are so many, many thanks to you for all that you have done for legal education for this school. In 2009, after the election of President Obama, Elena Kagan became Solicitor General of the United States, a job that we'll hear a little bit more about. And then she was nominated to and confirmed for the Supreme Court of the United States. And she's been serving there since 2010. It's unbelievable.
6 years.
Wow. So now,
starting my 7th.
Unbelievable.
Yeah.
What
Time
now?
flies.
Wow. You're an old hand at it.
Yeah.
What's your next job? No. What is a typical day for you in your current life?
A typical day. Well, one is sort of like another, to tell you the truth. It's very different from a dean's job. In a dean's job, one is not like another.
Absolutely.
But in my job, it is. I mean, there are the only difference being that there are days where we hear argument and days where we don't. So when we hear argument, a typical day is we go out to the bench in the morning and we hear a couple of hours of argument. And then either right then or a couple of days later, we go to conference where just the 9 of us, without clerks, without any administrative aides or just the 9 of us, sit around a big table and discuss the cases and decide how we're going to come out. And then I go back to my office. And occasionally there will be outside visitors of one kind or another, maybe a foreign justice, maybe a state Supreme Court justice, but really few and far between. Mostly I go back to my office and I do some more reading and I do some more writing. So if you don't like reading and writing, it's a kind of bad job. But that's what academics do too, reading and writing, so sort of without the teaching. And then I get up the next day and I do it again. But mostly that's, I think about hard legal problems and I read what people say in their briefs about those problems. And then in the cases, in the decisions that I'm assigned, I try to write what we've decided about those problems. But day to day, it's kind of it's a routine, and you might even say it's like, where's the excitement in that? And I guess the excitement and the challenge just comes from the substance of the work, that these are incredibly difficult, incredibly challenging, incredibly interesting, and often very meaningful legal issues, and that I have the responsibility and also the privilege of adding my thoughts to the resolution of them.
Well, we are grateful to you for doing that and for writing in a way that we can understand, which is not always true. I'm going to ask you to step back and compare this job with jobs you've had in the past. For example, being Solicitor General of the United States. And if you want to mention about being a dean, that's fine too. What are the hard parts? What are the joyous parts? What are the boring parts?
It's really different. I mean, it's a really different job from being dean. As I suggested before, I mean, dean, you wake up every day and you don't really know what you're going to do and what life, what's going to be put on your plate. And you decide such a wide range of kinds of issues, right? It's not just, there are a lot of different issues that I decide, but as dean, one day you're thinking about legal scholarship, and the next day you're thinking about designing a building, and the next day you're thinking about how to put together a multi-million-dollar budget, right. And the next day you're thinking about some hard personnel difficulty. And so you're required to be all kinds of different people doing all kinds of different jobs. And I used to think that that was the best part of being dean, was that I got to exercise a lot of different muscles and find out how to do a lot of things that I had no experience in doing. And that I think gave me a lot of skills that I didn't know I had when I started the job. And the job I have now is in some ways narrower than that, in the sense of I use the same muscles every single day. So, and although I learn every single day, and I hope I continue to learn every single day in the job, in some sense, I'm always the same person when I wake up in the morning. I'm always a judge doing the same things, as opposed to when I was dean, where I felt like being a dean had like lots of different roles in it, and you just had to go from one to another to another to another as fast as you could.
How about Solicitor General?
So Solicitor General was maybe midway between the two, but closer to what I do now. Monday was sort of like Wednesday was sort of like Friday, although the job had a few different components to it. The Solicitor General, for those, most people first years here?
Raise your hand if you're a first-year student.
Okay, so Solicitor General of the United States, it's really a cool job. It's the person at the Justice Department who is responsible for all the appellate litigation of the United States. And that means the person who decides when to take appeals from decisions that have gone against the government. It means the person who generally supervises the appellate litigation of the United States government, and the person who more particularly supervises the litigation of the United States in the Supreme Court, and argues a lot of cases in the Supreme Court. So once a month, every sitting that the Supreme Court has, the Solicitor General goes up to the court and argues usually the most important case that month, the case that the United States has the deepest interest in resolving. And so there are a few different components to the job. There's the arguing component, the kind of stand up at the podium and argue to the Supreme Court part of the job. There's the part which has the Solicitor General is responsible for all the briefs that are filed in the Supreme Court. So every brief comes to the SG, and the SG reads it and edits it and gets it into shape and makes sure that everything it says is something that the United States is comfortable saying before the Supreme Court. And the SG decides what appeals to take, as I said. And more generally, the SG often has to resolve competing views of what positions to take in both the appellate courts and the Supreme Court. In other words, there are lots of different components of the federal government, many agencies and departments and offices, and often they have different views about what position to take or what reasoning to use in a particular legal decision. And it falls to the SG ultimately to decide we're going this way or we're going that way, or we're going to try to forge a compromise between seemingly inconsistent or competing positions. And so that's a big part of the job too, and one that I liked very much. So there were different parts of the job, but again, it was much more than being dean. sort of being the same person every day.
How about arguing cases versus deciding cases? You just described part of the SG's role is deciding something, but ultimately the SG is an advocate.
Yeah.
And now you're not an advocate.
So which do I like better?
And which is harder? And what are the features of each?
Well, in some sense, the SG's job is harder. I'm always reminded of this because the SG will stand at the podium or any other lawyer, and I'm always reminded of how tough it is to stand there. I mean, we are a hard court to
An active bench.
argue in front of. We're a really active bench. People usually call that now a hot bench. We just bombard people with questions. We don't give them a lot of chance to speak, much less think. Nobody gets the opportunity to say, here are the 5 major points of my brief or the 5 things that I want to highlight. We basically take the view that we've read your brief, we know what your brief says. If you've been any good, we know what your argument is. And instead, we use the argument for, I think, a couple of different purposes. One is that every brief or set of briefs does leave you with questions in your head. Here's the weak part of your case, or here's just the hole that I see in your argument, and I'm trying to figure out how you would fill that hole. And it's an opportunity for the court to ask the lawyers, like, here's the problem with your position, or here's the hole in your position. And it's an opportunity for the lawyer to try to fix that problem or fill that hole. And in that sense, a lawyer standing before the Supreme Court shouldn't view questions as inconvenient interruptions. They should welcome those questions, because those questions are basically saying to them, here's what stands between me and a vote in favor of your side, and here's your chance to tell me why I should
roll with you.
Why I should be able to get to your side. But so that's one way we use argument, and it's a hard thing for a lawyer to stand up there and, literally in a half an hour, a lawyer might get 50 questions, and be expected to basically answer our questions in a couple of sentences, 2 or 3 sentences before the next question comes, and the next question. And the questions aren't ordered or organized. Yeah. They come from 9 people, each of whom has his or her different views about what he or she wants to hear about. And the other way we use argument is as a chance to talk with each other. So we don't talk with each other about a case prior to argument. We only talk after argument. So that means that the argument is the first time where we get to hear what our colleagues are thinking about a case. And what puts a premium on this, too, is the way we confer after argument. Because when we finally get to conference, we have a pretty formal method of discussing and resolving cases. So there are 9 of us. There are now 8 of us. But with a full court, there would be 9 sitting around a table. And it would go by seniority, Chief Justice first, and then by order of tenure. And each person would say what he or she thinks about the case and about the decisions to be resolved, and will cast a vote. That vote will be tentative, but it will be a vote.
And you're last.
I'm last, so that means everybody has voted by the time it gets to me. If you're second to last, it just means one other person hasn't voted. So the people at the last part of the table, people have voted. And so I'm very cognizant of that and realize that if I'm thinking about a case in a certain way, especially if it's a way that hasn't been well developed in the briefs, then I only have one opportunity to sort of float that theory of the case before people start voting. And that opportunity is
at
argument. And so when I go into argument, I usually have questions that are designed really to be questions. In other words, to get the lawyer to answer things that I think are really difficult about the case. But there are also questions that are designed to be messages, and those are messages to my colleagues about how I think the case ought to come out, or what I think we ought to be thinking about when we resolve the case. And so, the lawyer is kind of just it's the sort of like you have to do it through a lawyer. But you're not really talking with the lawyer. You're really talking with all the other people on the bench. And that makes things incredibly hard for a lawyer.
Yes.
So you have to be really good. And we are really lucky. We have now a fantastic Supreme Court bar, a lot of very skilled, very able, very experienced advocates who are kind of used to the way we work and who deal with it really well. So I think we all count ourselves very fortunate to have this bar, but it's still just an incredibly hard job to be a lawyer in front of the Supreme Court.
But it's one reason we actually use the Socratic method in class, is that being called on?
That's absolutely right. And, it's not the only kind of lawyering that anybody can do, right? So that there are lawyers that that really don't do that day by day,
and work on transactions,
and are very happy not to do that day by day. But for sure, I mean, litigating and courtroom litigating, whether you're before a district court or an appellate court or the Supreme Court, I mean, the Socratic method is a great training ground for that, and it's a great training ground, by the way, for the people who I talk to every day are my colleagues and my clerks. And I think if you're a clerk of mine, you're awfully glad that you've been trained in the Socratic method, because believe me, that's what I use. And that's what a lot of the lawyers that you're going to be dealing with, whether it's in a law firm or in a government office or any place else, a public interest organization, I mean, there are questions that have to be answered, and people are going to ask you a lot of questions in the course of your work, and you're going to have to be fluent enough in the language of the law to answer them.
And get to the bottom line pretty quickly.
Yeah, get to the heart of the matter.
Yeah. You mentioned that, sadly, you are now an 8-person court, and the loss of Justice Scalia is still being felt very keenly. I'm sure at the court it is felt keenly here. He is a graduate of this school. How and why was he influential?
Well, we do miss him just a ton, and I miss him a ton personally. I mean, he was a great friend to me. He was generous and kind. I had known him a little bit because of when I was in your place, and he was a graduate of this law school, and he came up to the law school on several occasions and was incredibly generous with his time, as he always was. He loved law schools. He loved talking with students. It was one of the things that gave him a lot of joy. But then, getting to know him better on the court was one of, I feel, a great gift of the last 6 years, both learning from him, because I think he had just extraordinary skills, and becoming friends with him. I mean, we did things outside the court.
You went hunting.
Yeah, he taught me how to hunt, which is sort of a story.
Something you hadn't done before.
I grew up in New York City. We did not go hunting on the weekends. But he taught me, and I enjoyed it quite a lot. And he was really generous in expanding his group of hunting friends to include me. We went out to Wyoming once for a few days, and we went to Mississippi once for a few days, and we, often would go down to Virginia to shoot birds. And yeah, I had a ton of fun doing it, both because of the activity and because I really enjoyed his and the other folks' company. But I learned a ton from him as a judge. I mean, nobody can. He's sort of an incomparable person, and his intellectual abilities and his writing abilities. But, I feel as though I've learned a lot from a lot of my colleagues, and everybody imparts sort of their own lessons about how to do this job well. But for sure, I feel very privileged that I got a chance to see him work. And what do I think will make him influential? I mean, I came up here last year, and it was a real honor for me. You invited me to give the Scalia lecture. And because I like conversations better than lectures, I had John Manning sitting in that chair, and John Manning and I just talked a lot about statutory interpretation. and what Justice Scalia brought to it and the changes that he made in that field of the law. And these are all first years, and you're going to be learning a lot about this in your leg reg class. But I think Justice Scalia profoundly changed the way courts read statutes and interpret statutes. And not just that he proposed a theory and then that it was out there as one of many theories, but that his textualist approach to interpreting law, even for people who don't agree with everything that he wrote and don't go all the way to Justice's position, it profoundly moved the way the court as a whole changed statutes. So it sort of moved everybody in his direction, even if everybody didn't end up in the exact place he did, in terms of looking much more carefully to the text of the statute, and in terms also of approaching with some greater degree of skepticism legislative history and other legislative materials that I think previously had mattered much more in interpreting legislation. So I think there his influence has been really quite extraordinary, and I don't think that that's going away. I mean, you can't predict anything about what happens centuries from now, but I think that that's going to have a very, very long-lasting effect in the way that courts understand and interpret statutes. Then I think, the other thing that he is known for, I have sort of different feelings about. The other thing that he's known for, it's textualism and statutory interpretation, and it's originalism in constitutional interpretation, where you look back to the original meaning of a constitutional provision, whether it was 1789 or whether it was, say, 1868 on the 14th Amendment, and you look back to what the meaning of that provision was then to the people who ratified it. And I think that is, honestly, I think that is going to, it's not a position that I espouse, it's a position I disagree with. But I think even beyond that, and now is not the time to talk about why, but I think even beyond that, I think it's probably not a position that's going to have the kind of influence over time that his statutory theories had. But at the same time, I think that Justice Scalia did something that's profoundly important in this area too. And what that is that he put on the table very clearly and forcefully, in a way that everybody had to deal with, the idea that any constitutional theory, any theory about how to interpret the Constitution, to be worth its salt and to be one that we should understand as right, has to deal with the question of judicial discretion. In other words, it has to impose constraints on a judge so that a judge can't sort of do whatever, so that a judge can't just say, my preference is this, or my politics is this, or that a constitutional theory has to impose some sort of constraints and discipline to prevent judges from doing whatever they individually feel like or think would be good policy. And I think Justice Scalia is very important in making clear the role of these disciplining mechanisms. And basically, I think after him, any constitutional theory, in order to succeed, has to show you how it's going to discipline judges, as well as how it's going to, in connection with how it's going to produce right decisions under the Constitution.
Well, I think he put it very forcefully by saying, you may not like the idea of looking to the original meaning, but tell me what's better. And I think that threw the challenge to everyone else. Right,
that's exactly right, that he always said, no constitutional theory is perfect. All I have to do is show you that mine is better than the rest. And I think one of the ways he said originalism was better than the rest was that it did constrain judges and prevent them from just sort of taking a case and using it to establish their own policy preferences. But there are other ways to put constraints and to discipline judges. And I think there are other constitutional theories which can satisfy his demand for constraint and discipline without going back to everything that we thought 1789, many
or some people thought in 1789.
Many hundreds of years
yes.
ago.
Yes, very good. So what are the challenges of being on a court that's missing one person? I mean, you're an even number in addition to missing a very influential member. How do you cope with this? It seems to me the court's granting fewer cases this year. Maybe I'm right, maybe I'm wrong. Looks like several important cases last year ended divided with 4 on one side, 4 on another.
Well, there's a reason why appellate courts have an odd number of members, right? I mean, have an odd number of members so that they can make sure to reach decisions and so they don't have to confront the ever-present possibility of a tie. A tie does nobody any good. I mean, presumably we're there for a reason. We're there to resolve cases that need deciding, answer hotly contested issues that need resolving. You can't do that with a tie vote. Now, I think that the court has done well over the past year in operating notwithstanding that difficulty, that handicap or disability, if you will, of not having a tie-breaking vote. I think enormous credit goes to the Chief Justice in that, who's really tried to forge compromise, who's really tried to get us to keep to a minimum the number of cases where we just throw up our hands and say we can't reach a decision. But that said, there have been those cases where we can't reach a decision, and there have been other cases in which, although we did in the end reach a decision, we did so only by narrowing them in a way that took off the table the reason why we took the case in the first place. In other words, narrowing them so far that it left undecided the real reason why we took the case and the real thing that's confounding the lower courts. And over time, that's a problem. I mean, the more months that the court is 8 members, the more the court has to deal with the possibility of not being able to decide cases at all, or not being able to decide the issues that made you take the case in the first place. I think we're going to continue to work as hard as we can. I think, as I said, that the Chief Justice has really encouraged us to do that, and I think all of us have tried hard to find ways of resolving cases, even which are not so apparent on the surface. But is that cost-free? No, it's absolutely not.
How do you decide what cases to hear? This is the petition for certiorari process. How do you do that?
So we have 8,000 or 9,000 petitions that come to us every year. And of that, we're probably only going to take 75 or 80 or 85. So it's really sort of 1 in 100. Every petition gets individualized attention. Each one is given to a clerk. 8 of the 9 of us are in something which is called the cert pool, and it means that we all get the same memo from a single clerk who is assigned to look at a petition and analyze it. And the petitions are all doled out, and a clerk will write a memo saying, here's what this case is about, here are the claims that the person raises. There isn't any reason to take this, or there might be a reason to take this, and here it is. I have to say, when you say 1 out of 100, it sounds sort of enormous. The cases that we talk about taking, we put on something called the discuss list, and then we talk about them in conference. We probably talk about 200 cases a year, something like that, and we then take a little bit less than half of that. And what we typically look for I mean, I would say 3/4 of our cases are cases that we take because different courts of appeals or state courts have interpreted federal law differently. And the idea is that even if the question of federal law is not particularly important in and of itself, that it's intolerable to have one person in one part of the country subject to a rule that another person in another part of the country is not subject to.
It's a national law.
Yeah, that federal law needs to be interpreted uniformly so that all people in this country get the same federal law. And so a lot of what we do is just that. We call it resolving circuit splits. In other words, there are courts of appeals, often called circuit courts, in different parts of the country. And the Second Circuit, say that's like New York, New Jersey, and so forth, needs to, if the Second Circuit comes out differently from the Ninth Circuit, that's like California, Oregon, and so forth, that difference needs to be resolved, even if the question in dispute is not particularly important on its own terms. So that accounts for a lot of the decisions we take. Then there are some that we take we take irrespective of a circuit split just because we think that they're super important, and because the court that needs to resolve that issue ought to be the highest court in the land rather than some intermediate court, as good as those are. So, for example, if a court of appeals invalidates a piece of federal legislation, the court will invariably take that case on the theory that you don't get to strike down an act of Congress finally and for good. If you're a circuit court, only the Supreme Court gets to do that. Some of my colleagues think the same thing applies if we strike down a state law, that too should only come from...
always come from your court.
Right. So, and then there are just some cases of a sort of random nature where you just look at and you say, there's no circuit split here, but it's just such an important question, we ought to decide it right now.
And so you vote on what cases to take. How many justices does it take to take a case?
Takes 4.
And how many does it take to decide a case?
Takes 5.
That's really interesting. So you can have some cases where some people really wanted the case and other people didn't want the case. That's very interesting.
That's possible.
Yes. And what about, sometimes you have cases that come to you not that way, for example, emergency stays and other kinds of cases, that not very often. And sometimes you even have original jurisdiction cases where you sit as a trial court.
Yeah, every once in a while. I mean, but we really don't. I mean, so an original jurisdiction case, the typical kind of case of that would be one state suing another case, another state. But because we're not really set up to be a trial court, usually what we do is we appoint a special master, and that special master does what a trial court ordinarily would do and produces an opinion, and then that opinion comes to us, and we end up functioning more like an appellate court anyway.
So while you have been on the court for 6 years, so you are a veteran, you are still the junior justice.
I'm still the junior justice.
And the junior justice is the only justice other than the chief justice that has a name. You're the junior justice.
Well, there's the senior associate justice.
Oh, senior associate justice. That's something I need to know. Do you have special duties as junior justice?
Yes. Yes. I mean, other than speaking last, I guess that's not a special duty. There are 3 special duties of the junior justice. The first is that the junior justice always serves on the cafeteria committee.
And that's thought to be some kind of not a good opportunity, although...
Every once, my colleagues and I have lunch together a certain number of times during the month after we have arguments and after we have conference, and sometimes I'll come in and somebody will say, who is our representative on the cafeteria committee? As if they don't know, and I say, I am, and they'll register some complaints. There's too much salt in the soup or something like that. And literally, I get to go to cafeteria committee meetings where the topics are sort of like, what happened to the good chocolate chip cookies? And I think that this is a way that the Chief Justice has of, when you get onto the court, you've gone through this process, and now you think you're an important person, and it's a way of, it's like, you're not so important after all. You have to spend an hour every month thinking about the chocolate chip cookies.
But you had experience
I
doing
did.
that.
It's true.
Here is the
it's like
dean.
I know from cafeterias. Yeah.
And isn't it true that you introduced frozen yogurt?
It's true. Just like I introduced coffee, I thought I needed a free coffee type idea. So there's now a frozen yogurt machine in the Supreme Court cafeteria.
It's really
good. And still, clerks come up to me every year and they say, "We hear you're responsible for the frozen yogurt machine, and we just want to thank you." So no clerk has ever come up to me and say, "We hear you just wrote that opinion, and we just want to thank you." But,
so that's one of your special duties. What are the other ones?
The other one, to be more serious, is one I like, actually. I'm responsible for taking good notes on everything that we do during conference, which is what we call the meeting where we decide matters, because other people have to know what we've done. The clerk's office has to know what we've done, and the legal office, the legal counsel's office has to know what we've done. So I take notes, and then when we're finished with our meeting, with our conference, all the other justices go away. I stay in the room, and the administrative staff of the court comes in, and I basically relayed to them all the decisions that we've made so that the administrative staff can handle all the things that need to be handled once we've decided to take a case or to deny a case or to do something else. So that's good. It's not decision making, but it just forces me to focus on everything we do. And
you do this by hand? Because you have really good handwriting.
Yeah. So I do it by hand. Yeah.
No problem. I can't read my handwriting, and maybe I'll just interpret it this way. No,
that would be a problem. And then the third thing I have to do is open the door.
What door?
Well, there's a door to the conference room. Actually, there are two doors to the conference room. It really is a very inner sanctum kind of thing. So there's one door that opens from the inside, and then there's a gap of about 18 inches, and one door that opens from the outside. So it's like a double door. And somebody will knock on the outer door and open that, and then I'll have to get up and open the inner door. And you might say, why are people knocking? Usually it's because one of my colleagues has forgotten something. It's like they've forgotten their notes, or they've forgotten their glasses, or they've forgotten their cup of coffee, or something like that. And somebody is bringing the forgotten thing to them. And I have to open the door every time. So that's the rule. Only the junior justice opens the door. I mean, I could be like in the middle of speaking, and still, pretty much, if there's a knock on the door, people would just sort of stare at me, like, why aren't you opening the door? But I have been the junior justice for quite a while. Not everybody is the junior justice for so long. Like Justice Sotomayor was only the junior justice for 1 year. Justice Alito was not the junior justice for very long. But Justice Breyer was the junior justice. I believe it was for, it was over 10. I think it was 11 years. So every time I kind of think, I really do not want to go to the cafeteria committee meeting, I think Justice Breyer went to the cafeteria committee meetings for 11 years. So what do I have to complain about anyway?
But you have to open the door and take notes at the same time. Okay. Are the justices communicating with people outside by email or something? Or how do they tell people, I forgot my glasses? Or
somebody usually will go to the phone.
I see.
And in fact, we don't bring in laptops or iPads or anything. We're pretty old-fashioned when it comes to that. So somebody will go to the phone and call their chambers and say, I've forgotten my glasses. Could you send somebody over? And sometimes I do that, too, to be fair. Yeah.
You already made reference to the quality of the lawyers before the Supreme Court, particularly the Supreme Court bar, the regulars who come often. And some have criticized that it's a smaller group than maybe in the past. It's become very specialized. So I wonder if you can just reflect on the quality of lawyering before your court and before other courts.
Yeah, well, I do think we feel very blessed to have the quality of lawyers that we have. And I know some people have written about the number of lawyers who appear before us is getting smaller and smaller, that there are many more repeat players. And I think that this is one thing on which all of us agree, is we see no downsides to this. That we think, I think, I'll say, but I doubt anybody would disagree, that the quality of lawyering, if better lawyering makes for better deciding. In other words, if you have people who write good briefs and who are able to get up at the podium and really answer your questions, understand what they are, understand where you're coming from, and provide the best answer that they can, that when the arguments are fleshed out, when the arguments are well made, it really enables you to have confidence that you're reaching the right decision. Now, if they're not, we work really hard to make sure that we do the work that the lawyers aren't doing. But it's not just easier if the lawyers do that. It's just it's better that we then get to focus on comparing the arguments, on seeing how the arguments interact with each other, who prevails on each, and we're not trying to do the lawyer's job too.
Are there some kinds of cases, though, where those best, most experienced lawyers are not involved?
Well, they have, over time, they have taken more and more of the cases. It used to be true that only rich people could afford lawyers like that. That's really not true anymore. That a lot of the lawyers who appear before us are willing to take cases pro bono, that their firms regard it as a kind of loss leader, and that there are reasons for the firms to want to do this, irrespective of whether they get paid for the individual litigation. There are now law firms, some law firms, there are some sort of sides of cases that are often that some law firms can't do, that they're conflicted out of. Like if you're suing a bank, right, that a lot of law firms represent banks, so that they're conflicted out of. But there have arisen a number of law firms that essentially, and a number of really excellent lawyers who are in much smaller firms that don't have those kind of conflicts. So very often, consumers groups, labor unions, things like that will go to one of those appellate boutiques. Law school clinics have become a very important part of this practice, and there are some really excellent law school clinics. So, but given all of those things, it's just less and less true that a person doesn't have access to really excellent lawyering because of the inability to pay. Now, sometimes still, though, I think that there is one category of case where people are not as well represented as they could be in not all of those cases, but in a good many of them. And this is something that Professor Crespo has written about recently, and that I've talked about before, is that I think too often in criminal cases that criminal defendants are often represented by the same lawyers who tried the case or who pleaded the case out, the original lawyers in the case. And occasionally you'll see a lawyer like that who is absolutely superb, but too often they just don't have the kind of experience that most people have when they argue before the Supreme Court and when they brief matters in the Supreme Court. And one of the things that Professor Crespo has talked about is different ways in which you could ensure that those kinds of cases are passed on from the lawyer who did the initial trial work to a more skilled, more experienced appellate lawyer.
You have encountered many people in your lifetime who have legal training but pursue many different careers. What are the kinds of interesting paths that people have? I mean, they could become judges and litigators.
Yeah.
Anybody do anything else?
Well, I think one of the great things about law school is you can kind of use it to do anything. And you know this as a dean because you talk to a lot of this law school's graduates, and you know that they do like 1,000 different things. So some are lawyers in the kind of classic sense, and some are, whether it's in a law firm or in a public interest organization or in government, but some go into policy work in different areas. Some go into business and become business decision makers. I mean, the world's open to you with JD, right? And that's a lot of the reason why amazing. Some people go to law school, and I think that there's nothing wrong with that, with this notion of I'll go to law school, it will teach me how to think, it will prepare me for anything I want to do. Maybe I won't need to know this particular legal rule if I'm going to be a policymaker or a business person. But this law school will teach me how to think in a very rigorous, analytic way, and that will serve me well no matter what I decide to do. Some people, I was always sort of amazed at the range of things our graduates did. And occasionally I would say, I'm not sure how law school
equips you for this?
Or equips you for this or benefits you in doing this. It's like the people who were in Hollywood doing comedy writing, It's like, well. But, I don't know. What are the great jobs that you've seen?
I mean, one of our graduates was one of the original writers for The Simpsons, and there are now books on the philosophy of The Simpsons. So I think he got something.
Okay.
But, found the commissioner of baseball.
Yeah.
Is one of our alums, founder of the Sam Adams Beer Company, one of our alums. Quite a range, people who are in internet startups, and you're quite right. People, I wonder if you saw the same thing. People in the government tell me that when you're sitting in a room and it's a policy question, you can pretty quickly tell who has legal training.
I always used to think that when I worked in the White House. I always used to think you could hear the difference in the way the lawyers and the non-lawyers talked about issues. And it's not that only the lawyers have something to contribute, but that I thought that the lawyers always were the ones who were able to kind of organize the issues and were able to bring a kind of rigorousness and analytic capacity to bear on them.
And say, we agree here, we don't agree here, let's focus in.
Yeah.
There are many people who are starting law school right now, some as JDs, some as LLMs. What is your advice? What's your advice about law school, about Harvard Law School, about Cambridge? What's your advice?
Well, I think that the unbelievable thing about this law school is just how much it has to offer, how many different kinds of professors and students and classes and extracurricular activities. And so sort of the world is your oyster here. I guess my advice is to try to sample things that you didn't know you were interested in. I mean, some people come into law school with passions and commitments, and that's fantastic. But one of the benefits of this place is that there's an opportunity to do new things and to discover new passions and possibly to develop new commitments. So I would do that. I would get to know, for every first year, I would try to get to know at least one professor well. Not just like, occasionally I'd go into office hours, but, try to really develop a relationship with at least one professor. At the same time, I think I would try to remember that your peers, the other students, I mean, this is an amazing group of students, and somebody who spends all their time in their libraries with their nose in the book is really missing one of the incredible strengths of the school, which is talking to all your classmates and learning from them. And not just to the classmates who share your interests, and not just to the classmates who you think have the same views that you do, but really, as much to the classmates who you don't understand how a person can have those views, so that you can get to understand how and why a person has those views. And I think that that's one of the things that's really important in any academic setting, certainly in this law school. that the conservatives speak to the liberals and the liberals speak to the conservatives, and both speak to people who wouldn't classify themselves as either one of those, and learn from other people and learn how they think and try to see what's valuable in what they think. And even if you come away disagreeing with them all the more, at least you understand what makes them tick, which is an important thing. And you might find that you do agree with them on some things, or change your mind, and that's a kind of great thing.
I think we have time for a couple questions. So raise your hand if you want to ask a question. There's one back here, and there's a microphone coming your way. And if you could identify yourself, say your name and your role here.
Hi, this is Paola Eisner. I'm a first-year student at Harvard Law School. I'm from Texas. My question is a little bit long. Sorry about that. Empirically, our current Congress is one of the least productive in our history. Traditionally, the Supreme Court has deferred to Congress to decide certain issues that do not fall under its own purview. Nowadays, in current circumstances, this expectation might not be realistic. Has this changed your views and the views of the court with regards to its own role and the balance of power between our government branches? And has it changed the ways that you as a court or you as an individual make decisions? And do you see any long-term shifts in the place of the court in American government?
I think it is not our job to decide whether Congress is the exact Congress we would want, whether it's productive or not productive, or productive in the right areas. I mean, it's just not in any way our job to evaluate Congress. Our job with respect to Congress is only to try to understand the legislation that Congress produces. And that goes back to the question that Dean Minow asked me about Justice Scalia, who played an important role in the courts trying to figure out what statutes mean. But we don't grade Congress. We don't grade the president. It's not a part of our job. I think it's one of the really important things about judging is that you have to understand what is part of your job and what's not part of your job. And what is part of our job with respect to Congress is when products of congressional action, that is legislation, come to us and have to be read and evaluated and interpreted so that people can know what those mean and what rule of decision applies in a case. And whatever else Congress is doing, we try to do that to the best of our ability.
Question right here. Here's a mic coming. Here it is. Yeah. And identify yourself, thanks.
Hello, I'm Albor Stolu, a Netherlands student from Switzerland. Thank you very much for this conversation, Justice Kagan and Dean Minow. I have a question about the importance of a clerk at the Supreme Court. So
I'm sorry?
Of a clerk.
Of the law
What's the
clerks.
importance of a clerk at the Supreme Court, and what's the actual job they have to do?
So I have 4 clerks, and each of us use our clerks differently, so I can only say how I use my clerks. I use them as sounding boards, and I also use them as, basically when I try to decide a case, I, of course, can talk to my colleagues about a case, but also I'll talk to my clerks about a case. Usually they divide the cases up. One person takes primary responsibility for a case. One person writes me a bench memo, just basically saying, here's the way I think about the case. Here's the way I think it should come out. Then I'll read that. All the other clerks will read it. Of course, I've already read the briefs and everything that's been submitted to us. Then I get all my clerks in a room, and we sit around a table, and we just bat things back and forth. And we say, how should we decide this case? And I know that the decision-making process is improved for me if I get a chance to listen to other people's views, and if I get a chance to press them on things and to ask them questions and to have to answer their questions. So for me, that's one of the most fun parts of the job, and also one of the most valuable. It's just talking about the cases and the issues in them with a bunch of smart young lawyers who've thought really hard about them. And then they're also involved in the drafting of decisions. Now I do my own writing, but they will. They'll typically give me a draft. Once I tell them what I want, I'll say, here's the way we've decided this. Then the full process kind of goes, they give me an outline, I look at the outline, we talk about it, we talk about what should be in the opinion. They'll go produce a draft. Then I'll look at that draft, and for me it serves as a kind of springboard to think about the issues more carefully and in more depth. I'll think about the draft, I'll think about what works and what doesn't work in the draft. I'll also kind of use it in the way somebody would use a research memo, that they've put together a lot of the citations and the materials. But then I'll sit down at the computer and I'll start from page 1 and write my way through a draft. And after that, of course, I have the Kagan draft, but it's just a draft. And what I do is I give that draft to my clerks, and we have a kind of systematized way of having a couple of different rounds of editing. And I'll ask them, just edit me like hard. Like, tell me what's wrong with any of the ideas, tell me what's wrong with any of the organization, tell me what's wrong with any of the style or how it can be made better. And then we'll just go back and forth and try to make the draft as good as it can be. So I get a lot from working with clerks, and hopefully, they learn a lot and they have a lot of fun. But I know it improves the quality of my work. It improves the quality of my decision making, I think, and it improves the quality of my writing.
You are already known as being one of the most memorable writers on the court, and that your prose is accessible and your sentences are sparkle. So who are you writing to?
Well, I always tried to write in a way that that ordinary people, you try not to dumb down an opinion. You're not writing to everybody in the world. But I always try to write in a way that even if you didn't know about a case, and even if you don't have a law degree, but if you're a good and close reader and interested in a person, that you can understand what I'm saying, that you can understand why we've decided a case a certain way. So and that's sometimes hard, because legal questions can be really arcane and complicated. And it's a challenge to be able to write about them in a way that ordinary people, especially ordinary people without law degrees, can understand.
Yeah.
And one of the things I think about, actually, when I do that, is I think about what I used to do when I was a teacher. In other words, I would go into a class every day and I would say, well, there are these people in this class, and they're smart and they're eager and they want to learn, but they just don't know all that much about the things that are on the agenda in this class. How am I going to explain it to them so that they understand it, but also so that they understand it in a way that sticks with them? And that's the same thing that I think about when I write decisions.
Would you join me in thanking Justice Kagan?
Thank you.